Good evening. My talk tonight is perhaps a little different to what you may have been getting. I won't be referring to any cases. They mean nothing to me now, except to fill them with clothes and go on a trip somewhere. My husband said you wouldn't laugh. Thank you. It's a pleasure to be here. I've always been a friend of the Queensland Law Society. When I was a community legal lawyer at Caxton Legal Centre, I was on a couple of committees. And while I was at Caxton Legal Centre, the Law Society bought a house in New Farm so that we could have permanent quarters, and it meant everything to us. It was a peppercorn rent, which we never paid anyway. But it was, and I should say that I was asked to speak tonight last year by Christine Smythe, when she was president. So I will be sending her my paper and telling her how it all went tonight. So I've called my paper, What is Justice Anyway? And as Christy referred to, I have broken it down into three thoughts. When writing the paper for presentation tonight, I thought it might benefit us all to take a step back and consider what exactly the law is about. Is the law about justice? Should we lower our expectations as lawyers as to what it is exactly we can achieve? Do we care as long as we have a satisfying, well-paid job? I was reminded when thinking on the topic of what was said to a group of first-year law students, including myself, by a law lecturer at the University of Queensland in the early 80s. He turned out to be a smarty pants, but he said to us as part of our Introduction to Law course, "Now let's get one thing clear. The law has nothing to do with justice. If you believe that, if you don't believe that, you're wasting your time here." Now, I was older than a lot of the students as a mature age student, and I'd come to the law with a certain aim in mind and a double dose of what I call the social justice gene. I inwardly rebelled against this proposition and continued to follow my course of working towards being a legal aid or community legal centre lawyer, and indeed I was. Later I'll share with you what happened to that dream eventually. But I wanted you to be aware as modern advocates of some new areas of thought in the delivery of justice in the broad sense, and also discuss the assets required perhaps to become a judicial officer. If it isn't your hope now, it may well be at some time in the future. I had no dream of becoming a judicial officer, but one day at law school, a few of the other mature age women and I formed a society, more or less to keep each other company. We were very much in the minority. And we were sitting around talking about what we might become. And an older woman who was doing law quite late and went on to have her own practice looked at me and said, "And you will be a judge." Now, my marks at law school were never great, not like my friend Ros Atkinson. She made it to the Supreme Court. I was a magistrate. I don't think that matters, though. But I was A, supporting myself, and B, rather political, so marching here and there, forming organisations, etc. No excuse. But anyway, it turned out to be true when I was made a magistrate, and not long after I saw this woman at a function and we ran towards each other. And I said, "You were right, how did you know?" She said, "I sort of knew." So I want to begin with some new initiatives within the court system which point to a future where perhaps justice can sit well within the administration of the criminal justice system at least. So I want you to imagine you're in court, let's make it the magistrate's court, and your client is up on several charges, just enough to make it highly likely that she will be sentenced to prison by the end of your representation on her behalf today. The prosecution are disinclined to agree to a non-custodial penalty, as your client has not always appeared when she should have in court, nor when previously placed on probation. She hasn't reported there either. The charges are related to theft, the purpose being to feed her drug habit. There are no charges of violence against her. Your client is addicted to heroin with a long history of drug use. She has avoided jail before because she has given up to the police, in other ways cooperated, those who have dealt the drugs to her, but now her time may well be up. She has tried methadone treatment but fell off that wagon, as she has at other times when she has tried to get off drugs. The court is busy, as it so often is on such days. The magistrate hears the facts and submissions from the prosecutor and yourself and sentences your client to 1 year in prison, suspended after 6 months. Your client has 2 children and is not sure who will care for them, and they look headed for foster homes. You had raised the issue of her children. She's a single mother to the magistrate, but he had commented she should have thought of that before she continued to use the dangerous drug. As he is having such a busy day, he will move quickly on to the next case. Now, I want to present another scenario based on the same facts. You and your client turn up to a court other than that busy call-over sentencing court. At the previous call-over, a procedure has been outlined where your client could appear before the magistrate's drug court. So when you do turn up there, your client having been given bail, you will notice straight away it's a busy court in that there will be a police prosecutor who is aware of the sentencing options available to your client, which I'll explain briefly, and who understands that your client will not necessarily, the prosecutor will not necessarily press for a custodial sentence. The idea basically is, if the client is prepared to plead guilty, the sentence will be adjourned for some time, but your client must agree to sign up to rehabilitation and retraining, and will appear regularly before the court, and there will be a report from the probation officer, the people in charge of the program, which may include or start with detoxification and move through other programs, including possible retraining for court. But the main thing is to get the person off drugs so that he or she can start to think seriously about where her life or his is going. What it demands from everybody in court is quite a different thing to what usually goes on in courts. The oath you take is to treat all fairly and without, I forget it now, I've taken it twice, so I can't remember it. But the traditional thinking, which I think is thinking within the square, is you see the client once, twice, 3 times. If you're a defence lawyer or training to be, you'll know that when it's that bad, you say to the client, bring your toothbrush. That's an old joke in the criminal law profession. And everybody knows in court your client's done it. It's hard when you're a magistrate or a judge to send anyone to jail, but there comes a time when everyone in court, especially the defendant, knows that they've been given every opportunity not to, if they have indeed exhausted all the non-custodial sentence options. But instead of going to prison, where they may well come out still addicted to drugs and never believe there aren't drugs in jail, will probably have had minimum treatment for their drugs, have even better connections with who deals in them, and be back and forth between the courts till either they overdose, lose their children, lose their jobs, and will be in prison for some time. So the idea of these, I've gone into them in some detail in my paper, but basically they're about a different concept, which is to use the power, authority and privilege of the judicial officer to actually intervene in that person's life. You may get to know them quite well. You still have to remain somewhat aloof because, say they're on the rehabilitation program for the drug court, continually fall off it, you will still have to sentence them to prison if they can't learn how to change their lives. But for a lot of judicial officers, it's a great challenge, and it only suits some of us. A lot of the higher courts in Queensland don't approve of it, as they have neither drug Murray courts, Aboriginal Torres Strait Islander courts, or other courts as yet. They do in other courts at that level throughout Australia. So it's a challenge. It takes a certain personality of a magistrate or judge to have the patience and the interest in actually assisting these defendants and the government to fund programs for their rehabilitation and take considerable time over these people. The idea came, in my case, through the concept of therapeutic jurisprudence, on which all specialist courts are based. It grew out of the experience of judges sitting in Californian courts in the US, beginning to think of themselves as becoming mere processors, almost administering the justice system rather than bringing about meaningful outcomes for all concerned. They developed the idea that courts could actually use their considerable power to reduce recidivism of perpetrators, actually intervene in the lives of such people, which may break the pattern of the debilitating, dangerous and perhaps doomed path which their lives are taking. I'd be interested to hear in discussion later what you think of some of the ideas that I will refer to in these courts. In Queensland, there are, as I've said, several specialist courts dealing with domestic violence, where time is taken to ensure the safety of the victim and the perpetrator can be offered appropriate programs for rehabilitation. Then there's the social blight of homelessness, where again circumstances contribute to offending. This unfortunate lifestyle is addressed in the special circumstances sentencing list. These courts are sometimes supported by legislation, as is the Magistrates Drug Court, sometimes not. Where there is legislation, you have a better opportunity or chance of having programs provided by the government. One court in Queensland which is not the subject of specific legislation is the Murray Court, which operates in Brisbane and several other locations in the state. If you have I'll call them ATSI, Aboriginal Torres Strait Island client, you will need to be aware of the procedures in this very different court. Mostly the defendants are represented by the ATSI Legal Service or the Legal Aid Office, but maybe sometime some of you may work in those areas. The Brisbane Murray Court is located in the Central Magistrates Court. The first thing you'll notice when you walk into this court is that it's a very attractive court, with a large oval table in the body of the court, with a beautiful Aboriginal piece of art built into the table. There is some Indigenous art on the walls, some done by prisoners. The next thing you'll notice is that the magistrate is not sitting on the bench, nor is she robed. She's sitting at the large oval table, and on either side of her are two elders, Indigenous elders, who have duties as part of the court. The aim again is to reduce, in this case where possible, the overrepresentation of Indigenous people within the prison system, and this can be achieved by reuniting them with their culture from where they have strayed, treating addictions which lead to their criminal behaviour. Now, the other part of these courts which can be considered controversial is that here we have, say, with the ATSI courts, one section of society being treated differently to other sections. Because of their historical loss of land, heritage and belief systems, and their subsequent lower socioeconomic status, one must consider what is justice in that circumstance. Special consideration for a certain group in society, perhaps, but do all people come as equal before the courts? A very long-held legal principle. And I know we'll all consider it ridiculous to consider that a corporation with deep pockets to fund the best QCs around will not be as well represented as by a tired, overworked legal aid or Aboriginal Legal Service solicitor. Absolutely no personal reference to anybody there. So should they be treated like everyone else? After the establishment of the Murray Court that evening, it was a wonderful day. That evening I was interviewed for the 7:30 report, as it was called then. Nice, attractive young woman turned up. Shouldn't mention she was attractive, but she did have amazing skin. And we were very friendly before the lights came on. And as soon as the lights came on, she looked hard at me and said, "So, a special court for Aboriginal people, what about everyone else?" Now, I'd hung around with journalists a bit, I'd done a little bit of the media. We were all on a high from this, we thought, wonderful new initiative. And I thought, "You're not going to get me, honey." And I said, "Absolutely." She didn't know where to go. And how I explained it was, if you look at the considerable disadvantage of this particular section of society, they need special attention, something along that line. It shut her up for a while anyway. I'm mean, aren't I? So the position of the elders is interesting. It is not their position to, they can advise on sentence, but mostly what they do is advise the magistrates on the background of the defendant. They may know them or their parents or grandparents well. They will be assessed as to their suitability, etc. The elders I've had experience with. When I was back as a magistrate at Caloundra, I was asked to establish one, and I almost said, "Oh no, I don't sit on them, I just set them up," you see. But I did, and it was most enjoyable experience, for as much as it can be enjoyable, mostly because of the relationship I could establish with the elders. Wise people. I was privileged to meet them, and they could tell me about their culture, and I could tell them the difference between a community service order and a probation order. One day, at our lunch break, one of the elders said to me, "I think you should go to jail." And I said a couple of things. A, he's not fit for it yet, right for it, but also our whole point is to keep Indigenous people out. So you just got a bit carried away. But I made clear that I did the sentencing, no one else. As I explained about therapeutic jurisprudence, in a paper entitled Therapeutic Jurisprudence and the Rise of Emotionally Intelligent Justice, I like that expression, Michael King describes, TJ I'll call it, as an approach focused on the potential for law to improve individual well-being to the extent this is compatible with legal principle. I don't think it can be said better than that. As I've described, the process involves a magistrate or judge working collaboratively with an offender to develop a rehabilitation plan and future goals. Let's remember that some defendants would rather do the time. Commit the crime, do the time. There is a culture among criminals, and they say, let's just get it over with. They see mates in there. I have seen this. And they, again, may come out, though, worse than when they went in. Most importantly, TJ, as I'll call it, must be implemented within the context of statute and the common law and achieved consistently in accordance with traditional judicial principles such as independence, impartiality, fairness and integrity. Let me conclude that section of my paper by saying, while therapeutic jurisprudence may continue to raise eyebrows amongst some members of the judiciary, it reflects an important endeavour where the traditional judicial model of decision-making operating in isolation is inadequate to the task, which I would argue it is. So moving on, tips from the bench. Why have a retired judicial officer to talk to you if she cannot give advice to new and young lawyers from both parts of the profession on how best to make your appearances in court wins for all? Here are a few of my thoughts. And let me say, I do miss court. I miss the theatre of it. It's quite theatrical. I miss being the boss. You are it, as I'll describe later, and how terrifying that was at first. But you can also meet with some great intellects, though not the best QCs in the land might be before you. And in the magistrates' court especially, you have such a variety of law, not only criminal, civil, domestic violence, these specialist courts, industrial law, etc. It's a great job. But let me say this. Firstly, courts can never be an even playing field. The judge or magistrate has the ultimate say, and respect is demanded and required. The exchange for the respect shown is, as I have always believed, the judicial officer is required to behave in a polite, courteous manner and to be fair to all who appear before them. The arrogant, cranky, unpleasant judge or magistrate exists, along with the ones who enjoy making new lawyers particularly nervous and jittery, or just being outrageous towards them. There are legendary stories of blasts from the bench, but they are often touched with humour. I hope there are still some characters out there, because there certainly have been amongst the judiciary. The best you can hope for, or ideally though, is fairness, consistency and timely judgments. I consider the basic skills of a good judicial officer. As you appear more in court, you will get to know the judges better. Learn their preferences for long or short submissions, usually the latter. Never bore the judge or magistrate. It won't be pretty for your client. If you are submitting that your client, if not sentenced to jail, has a job offer or whose wife is expecting a baby, have a letter or certificate to prove it. Otherwise, it's wasting everybody's time. Have your sentencing precedents ready. Don't ask for too much leniency, you look silly, but never get in. My husband was a duty lawyer when he worked at Legal Aid, one of the best, I was told. And a magistrate wanted to send his client to jail. My husband was so desperate to interest the magistrate in, that she had something else in her life other than drugs. He said she does macrame. And he could see that the magistrate, and some, they don't have stamps now, but you used to use stamps. And some lawyers could say they'd know where the stamp was and knew if they were getting probation, community service, whatever. As he was reaching for the stamp, my husband would not give in till he listened to him and he saved the woman from jail. So you do have to be persistent. On the other hand, I had a busy day at the Oakey Magistrates Court once, and this nice young man from Legal Aid Toowoomba was there, and he started to speak in mitigation of his client, telling me that he'd been a hard worker all his life. He started at 17 and the defendant was 61. He went through almost year by year. And I said to him, Mr. So-and-so, I've got a big day. I'm only here for the day. I'm from Dolby, blah, blah. And he didn't get it. And he picked up at the next year and I said, no, I don't think you understood me. Anyway, he didn't get it and I just sat there and let him go through it. I mean, why should I get heartache over it? But so listen to what the judge is trying to tell you. It can be terrifying at first to appear in court. I know nothing after public speaking. That is, and I'm obviously over it, though I'm rushing things a bit tonight. Haven't done it for a while. I don't know if you agree. It is terrifying to stand in court. One of the reasons I didn't go to the bar, and I was always pushing young people, especially young women, to go, was that I was terrified I would either be referring to totally the wrong issue or I'd be asked about a case and I'd never heard of it. And there is the story of a judge whose associate handed him the latest decision from the High Court that morning, and he asked one of the barristers, did he know of this case? And he said, oh yes, I do. And he said, that's interesting, it just came down. So don't try to bluff either. There is no reason, in my opinion, that solicitors cannot run minor trials or other civil matters in the Magistrates' Court, or indeed do district court sentences. When I was solicitor in charge of legal aid at Ipswich, His Honour John Robertson of the District Court encouraged me to do the latter. And legal aid was terrific. You'd get your precedents through and everything, and why not? Young barristers, any of them here today, might want to shoot me because, of course, the Magistrates' Court has always been a good training ground for advocates. But if you want to do it yourself, do so. If a solicitor appears often enough as an advocate, he or she may decide to go to the bar, and that's a good thing. When you're in court, you need somehow to differentiate your client from the ordinary if you get a busy day or a busy magistrate. It will become obvious if you have just met your client, which is not unusual for a barrister to meet his or her client outside the court for the first time. So when the magistrate, say, asks a question, you'll have to ask your client. You should make the best attempt you can. And so let's just talk about ego for a moment. Believe me, you need a healthy ego to best represent your clients in any court, in any jurisdiction. You can be opposite someone of considerable intellect, maybe with more experience than you, and a clever judge or magistrate, as I say, waiting for you to make a slip, perhaps. Never estimate. It's a tough game, and more experienced practitioners and even some judicial officers can sense fear and smell it, and it's tempting. No, it isn't. I believe I was always decent. I've talked about criminal law because that's most of what you do in the Magistrates' Court, but we did other, as I said, other matters. So there's the Criminal Law Club, the Family Law Club and the Civil Law Club. They see each other every day, they go to conferences together, and often the judicial officers are there, so you all get to know each other. And it's important because, you know, the stress of being in court, representing your clients in every way can get on top of you. But above all, when preparing any case in court, preparation, preparation, preparation. There is no excuse for it. If any of you have the eventual aim to be a judge or magistrate, it is a fine thing. As I say, they're great jobs. Like any career, you need, though, to plan well for it. You will need to have a mentor. I see a career as building a solid base and adding bricks to help you up to climb to your eventual goal. Solicitors are often made magistrates, not so often judges, but they are. Sitting on various tribunals is good training for the bench. No amount of advocacy, however, from one side of the bar table, I can assure you, is nothing like sitting on the bench for the first time when it hits you that the buck stops with you. You have to make a decision and someone's life may be changed forever. It's not for everyone, and some barristers and solicitors have been appointed and leave because they didn't realise what making a decision is about and it didn't suit them, and fair enough. But it is very gratifying work and, of course, a huge privilege. How am I going? Okay. I wanted to talk to you about resilience, what it is and why you'll need it. I believe resilience is a fancy word for courage under pressure. It is the ability to survive a potentially life-destroying or traumatic experience, to overcome the resultant pressures and to get on with having a good life. It is not easy. If you are born with it, that is fortunate, but it can also be learned. I have found throughout my career that a considerable amount of resilience has been required. Sometimes those bricks you are attempting to put in place fall away. You don't get the job you thought you were perfect for, leaving a gaping hole in your career plan. Sometimes you realise you are building the wrong type of structure and have to decide to take a different path. Sometimes personal difficulties threaten to turn your life upside down with unpleasant results for your career. I guess a divorce could fall into that category. Fortunately, not one of my experiences. Then there are the risks one must take to go to or not to go to the bar, to go into a partnership or not in potentially difficult economic times. For women in the profession and those from diverse backgrounds or disabilities, it cannot yet be said that there is no longer discrimination. However, things I think are better, especially as so many female graduates are sought after to join firms where previously the net would not have been thrown wider than could be supported by the old school tie. When I was made a magistrate in 1995, there were 4 women magistrates in total out of 75. Now I believe they make up 40% of the total, and there are at least 3 Indigenous members on the bench. That began with Matt Foley's, as Attorney General's, affirmative action plan in the 90s. He definitely, in my humble opinion, started the trend, and it has continued. I thought I was going along quite well, becoming Deputy Chief Magistrate in 1998 and Chief Magistrate in 2000. For those of you who know my story, I won't go into details, but in a nutshell, suffice it to say that I went into the job of Chief Magistrate as a reformist and as a believer, as I'd said, in therapeutic jurisprudence. I was the first female Chief Magistrate ever. I was appointed over several other people who may have wanted the job, but I got it. I came from the legal profession from my job as solicitor in charge of the Legal Aid Office at Ipswich. Most of the magistrates at that time had come from the court system itself, having studied law but never practiced in a courtroom. They had no idea of what it was like when your client didn't turn up. And I'd been rushed into, when I was solicitor in charge at Ipswich and doing duty lawyer, the clerk to the magistrate would come out and say, "He's ready for you." And one day I said, "Well, I'm not ready for him." But I had to go in and explain that because people weren't turning up, I had a long list, etc. We did do the ones I could do, though. So I had challenges to overcome, but I had plans for exciting change and process. I worked hard, hoping that I could take the magistrates with me. In fact, I asked them to think outside the square at the first conference, at which I addressed them as Chief Magistrate. I believe one could almost have counted the hackles rising on the necks of the still male-dominated audience of magistrates at that time. But inspired by some modern thinkers within the magistracy and belief in my own goals, I charged ahead. I'll cut to the chase. Envisage scene in May 2003, 3 years after I was appointed Chief Magistrate. Standing in the dock in the Supreme Court, a Judicial Officer in the dock, not sitting up there where I was used to, and hearing the word guilty coming from the mouth of a foreperson of a jury, which had heard charges prosecuted against me and defended by me. The charges arose out of a magistrate referring me to the Criminal Misconduct Commission over an email I had sent him asking him to explain his recent behaviour towards me on various matters. He was a coordinating magistrate in the court, and I used words to the effect, I'd want to talk to him. He took it perhaps the wrong way. I was charged with perverting the course of justice by supposedly interfering with a witness in a matter before a committee of superior judges about a refusal by a magistrate not to accept a transfer to the Townsville courts, although she said she would go earlier, and that particular magistrate had given an affidavit in support. Consequently, I served 6 months in a women's prison before returning to my life and happy marriage, but without a job, with a criminal conviction, and somewhat shattered. I will leave it to you should you wish to read the case of Fingleton and the Queen 2005, the High Court, but as I was exonerated by that court in a 6-0 judgment that I had an immunity against ever being charged with a criminal offence, as long as I hadn't gone out and robbed somebody or assaulted somebody, of course. I was then decided what to do, and some good friends said, go back on the bench, and I said, are you kidding? I was obviously not going to be Chief Magistrate again. Funny that. They didn't want me back. Anyway, so I made the decision to go back to Caloundra, a lovely new court and nice place to live. But the return took, as you may imagine, a combination of guts and determination. But what was I to do? Being a magistrate was what I had done for some years and I think been good at. My reputation with practitioners was firm but fair. That suited me very well. I was only asked last week by a friend if I had sent anyone to jail that second time, having been there myself. And I said, of course, one could hardly escape doing that. But also, I'd taken the oath again. I could not have gone back. It's an odd story, isn't it, to go back, be sworn in twice, all of that. But you don't know what life's got waiting for you. And, and of course, but I believe from the practitioners at Caloundra, the defendant said of me, she has walked the walk, that woman, she's all right. Not a walk I chose, but there you go. So where did my resilience come from to get through all that? I had tremendous support from those closest to me, my husband, family, and old and close friends. When I was in prison, I received over the 6 months a total of 1,000 letters and cards, about 30% from strangers. I made it my business to reply to my mail each day, as it was a discipline of sorts. And I thought if a total stranger was nice enough to write to me, I could at least write back. At one stage, I had to resort to a standard letter. There were so many, but I was determined to thank those who were keeping me in their thoughts and prayers. I had always been a busy person, and I kept up a routine of sorts to keep me focused. I was determined never to break down. I felt, and really knew, that there were some people possibly rejoicing in my dramatic demise, and I did not want them to think they had won over me. I had been, and still am occasionally, accused of having a large ego. And let's think on that for a moment. I doubt a man in my position would have had that criticism laid upon him. Men are supposed to be egotistical, sure of themselves, stubborn in their beliefs, and not suffer fools gladly. Pretty much sums me up. I'm also pretty nice, pretty kind, pretty soft, but when you're in a management position. So, as a woman, having painstakingly built up my self-esteem over a sometimes difficult life, I just found that whole thing too much. In my case, I had, while Chief Magistrate and during my less successful time, a strong belief that I was achieving good things, such as access to capable representation for disadvantaged groups, representation for legally aided clients before the court, and as Chief Magistrate, innovative changes to the way the courts work. My belief in my innocence was unshakable, but it took a higher court outside of my home state to confirm it. It helped me during my time in prison to search for role models. For example, I read Nelson Mandela's biography. Not a great library at the women's prison, but I found a few things there. And the story of Chris Reeves, Superman, who had fallen to earth in a horse accident, and the tale of a woman doctor working in Antarctica who operated on her own body when she had breast cancer. So you've always got to put your problems in proportion, threaten as they do to overwhelm you. And seek help, professional, if you need it. There's no shame in that. Finally, never ever lose your sense of humour. You had in prison, I think it was, you had 2 calls a day. You sort of put the money in and you could use some calls. So first obviously was my husband, and then one of my closest friends at the time, still is, said, I can't believe you'd call me and make me laugh about something that happened during the day. I wouldn't tell her some of the slightly sinister things I witnessed. And I said, well, I'll go mad if I can't find something to laugh at. I believe we are given senses of humour for purposes of survival as well as for sheer enjoyment. Be hyper-vigilant to the sillinesses of bureaucracies, systems, practices, autocracies, indeed. There is always someone having a worse day than you and who could do with a bit of lightheartedness. Now that I'm retired, and you do have a lot of time, we live in the city, I walk around the city, I often comment on someone's clothing and compliment them. Well, you think you'd given them, a beautiful pastry from Bonsoir or something. They're so excited. It doesn't cost me anything. I began to write my book in prison, firstly out of a feeling of deep loneliness. A judicial officer in prison, I can't think of a comparison. The Pope in I won't say that word. Anyway, facing daily a continued fixation by the media as to my condition within the prison. But I wanted to remember the feelings of hypervigilance, disbelief as to the turn my life had taken, the ruination of my hardly built career, the loss of my happy family life, however temporary, in relation to the last one. I've often thought of that sentence spoken by the lecturer in Introduction to Law about the law having nothing to do with justice. As I stated, I eschewed that statement immediately and began my studies and my practice of the law with much higher hopes than that, and I hope I brought some justice to some people. However, not a great surprise then that when searching for a title for the book I wrote about my experiences at the hands of the criminal justice system in Queensland, the book's title, Nothing to Do with Justice, seemed appropriate. It is available online, should you wish to read it. I'm told it's like I'm talking to people, and I said, well, I was reaching out. It's a dreadful loneliness in there. As I say, people asked how I could have returned to the bench after my exoneration, and I said, but that's just it. The system worked. The system I believed in worked. The highest court in the land is there for a purpose. They are the best, and believe me, it's fascinating to watch them at work. And in my case, it was necessary to undo one of the greatest cases of miscarriage of justice in the Australian legal system, and I quote from Justice McHugh of the High Court at the appeal. That I chose to re-engage in it was, for me, a symbol of optimism in the system itself, and why I encourage you all to plan well, study and work hard, find good mentors, most important, and head for the top. A word of caution though, watch your back. Thank you for listening to me.
Thanks so much, Di, for your time and your insight. That's fine. We're not charging here. Especially the power of resilience and particularly kindness. I identified to your talk as a mature age student. I think I had that same lecturer. He said, actually, the law's got nothing to do with social justice, was what he said to me.
Took it a step further.
Yeah, and my first job was also at Caxton Legal Centre, and I was a duty lawyer at the Federal Magistrates Court. So I had many experiences.
Sorry, I didn't know that.
I had many experiences of gaping at federal magistrates as they asked me for 75 two-factors, begging them to stand the matter down. So I appreciate that the judges also know that it's a nerve-wracking experience to stand at that bar table. So there are some time for questions. If anyone has any burning, searing questions they'd like to ask Di, Stafford has an iPad and it contains questions, apparently. It's a magical thing. They didn't let me have charge of that, but feel free, if anyone's got a question, just raise your hand and we'll just send someone around with a microphone. Oh, here we go, someone at the front. Step one.
Thank you very much.
Hello, what's your name?
Alexandra,
And where are you working?
JHK Legal.
That's good.
Thank you. My question is...
It's good for you. I've never heard of them.
My question is, what was your biggest challenge at the bench and how did you overcome that challenge?
Early on, you never know what you're going to get in the magistrates' court. And it was a committal as to whether crabs sent from, it's a long time ago, Northern Territory to Queensland was or was not a breach of the Constitution or something. Well, that was the point being argued. So I went in and there was a senior QC, since retired, juniored, ironically enough, by the current Chief Justice, Kate Holmes. And I always went to the toilet. No, that's very crude. And I thought, wow, this is... And so I sat there and I thought, well, you want to do this job, you do it. And the Chief Magistrate at the time, Stan Deere, said, if you're ever in doubt, Di, adjourn and ask somebody. I didn't have to ask anybody. I actually adored constitutional law at school. But it was it was quite a challenge. Someone whose intellect you revered, but the brighter and the more experienced, the more polite. And he knew I was new to the bench and he was not out to embarrass me. So I adjourned. It was not the final decision, but it was a question on the way through, point of something. Gee, when you leave, you really leave. But otherwise, and of course, the magistrates' court, we don't have the luxury of a jury, so it rests with you. So you find, law, facts, decision sort of thing. And they were sometimes written under pressure because you had so many, you put them off, you end up with 20. And so you keep people for a while and go off and write it. Only once did I think in the shower that night that I'd been conned by a civil lawyer who was doing a criminal case, not that good looking actually, but who had conned me. His client definitely stole the bracelet and I made an extempore decision and I should have left it till the next day when the shower woke me up. But just early on, of course, come all the challenges. Then the challenge later on is that it may seem too ordinary, too repetitious. And as I say, that's where, if you've got an intellect, you're just not going to sit it out till retirement, take a significant superannuation, you might want to engage more with the people before you. I realised one day that I hadn't been making contact with the defendant, only his or her solicitors. And of course, that was shocking. So I made a point then. You can get into bad practices. Anyone else? Any online? We should limit it, shouldn't we? Because I've gone over. Yeah, drinks to be had.
Any more questions? I'm standing right in the bright light.
Anyway, thank you for having me, and I wish you all the very best in your careers. As you can see, what happened to me did not embitter me against the law. There can be injustices, but they can also be overturned, and fortunately mine was. But mostly, great things are done every day in courts by the profession and the judges and magistrates.
On that note, thank you so much.